Morning. Finally, you feel winter has set in. Yes.
Maybe. Lord, item number 13. Lord,
Item number
13, my lord.
13. Yes.
Yes. Can it be, my lord, posted on, my lord, 6th of November? Because on that day, another analogous matter has been fixed. My lord.
As prayed for by Mr. M.U. Mondal, learned counsel appearing for the petitioner, relist on such and such date along with such and such.
Yes. Case number, my lord, 1902-2025. On 6th of November, it is fixed.
Yes. Yes, Mr. Datta.
May it please your lordship, I beg to mention item number 11 with the consent of the other side. I am appearing for the private respondent. On the last occasion, we were directed to file an affidavit, but we could not prepare it. So,
You are there.
Yes, Milord.
Any objection?
Yes, Milord. I have mentioned it because the family mentioned matter, Milord. I am the first wife, Milord.
Okay, let
So let
after
them
be called.
Let them file the affidavit, Milord. If
I can file the affidavit and it can be fixed on 13th of November.
November, Milord.
So have you filed it today?
No.
You're going to file it. Okay. Heard Mr. S. Sinha,
Yes.
learned counsel for the petitioner. Also heard Mr. S. Datta, learned counsel appearing for the respondent APDCL.
The private respondent.
Respondent number 5.
Yes.
Anyone for APDCL? Okay. Mr. Datta seeks 2 weeks time. 2 weeks time to file return in the matter. It is made clear since the matter pertains to retirement benefits, the return shall be positively filed by the next date of listing. Relist on such and such date. Give the
13
date.
Milord. 13 November.
Obliged.
May I please, Your Lordship, I would like to mention item 34. Adjourn this matter and fix this matter on Tuesday.
Why Tuesday? What is so auspicious on Tuesday?
As my senior sir instructed me.
Oh, because your senior have. But suppose Tuesday is not convenient for the court, then
Dim fit
Yes.
as a dim
Yeah.
fit.
Tuesday. Okay, as prayed for by Mr.
Jat Hussain.
Jad Hussain, learned counsel for the petitioner, relist on such and such date.
Thank you.
Yes.
Right.
May I please, Your Lordship? Also, I'd like to mention item number 10 of the daily list, Milord. Here, my lord, we are required to file rejoinder affidavit to the affidavit in opposition filed by the respondent, Milord.
Uh,
For respondent number 2.
all right. As prayed for by Mr.
A. Gayan.
A. Gayan, learned counsel for the petitioner, relist on such a relist after 2 weeks on a date to be fixed by the registry to enable the petitioner submit rejoinder against the affidavit in opposition filed by
Respondent number 2, 3,
respondent number 2, 3, and
4.
4. Much obliged.
Yes, please call the list.
For ambition, item number 1. Wait, please, Lord. Matter pertains to non-payment of salary.
Yes,
and
but-
the regular. What happened? The
Why
respondent,
salaries have been not.
respondent number 1 has filed a affidavit in opposition, but other respondents have not filed till date.
So what is the stand of the respondent number 1? Who's respondent number 1?
The government, my lord.
Mr. Pukan, you are for?
I'm for the government, Milord.
What is your stand? Why salaries have not been released to the petitioner? Since when? When, Mr. Saikya?
My lord, it is from 2007 to 2021, my lord.
2007 to 21.
In my lord.
And after 21?
After 21, my lord, it has been paid.
So the area salaries.
My lord.
Yes.
Milord, they don't fall under the category, Milord. And plus, Milord, the finance department's affidavit also will be required.
Finance department affidavit is
Who's
required.
appearing? Yes, Mr. Chalia. Mr. Chalia is always in the back.
If I can get a copy, why finance department first the administrative.
What copy you want?
The copy of the affidavit filed by.
Yeah, internal. Why do you need the court to give direction to the government to share copies with one another? You all are the department of the same government. You're not of another state.
Yes, Lordship. Lordship, I'll take-
Then why that coordination is not there?
Yes, Lordship.
Why should even these things be mentioned before the court prior to the matter being listed? Yesterday night, you both should have consulted and had a shared, Mr. Fukan, share your affidavit. These should have been shared overnight through WhatsApp so that the judicial time are being saved.
Lordship.
Unnecessary matters are getting lingered, salary matters. Yes, how much time?
Lordship, grant me 2 weeks time, Lordship.
Mr. PJ Saikya, learned counsel for the petitioner. Also heard Mr. A. Fukan, Learned Counsel, appearing for the
My lord, elementary education department.
which
Elementary.
Education Department, and Mr. A. Chalia, Learned Standing Counsel, Finance. It is submitted at the bar that though an affidavit in opposition has been filed on behalf of respondent number 1 on 24/24, however, in order to effectively decide the issue in hand, the return of the finance department is necessary. Mr. A. Chalia so and so seeks how much time?
2 weeks time.
2 weeks time to place the return, to submit return on behalf of the finance department. Prayer is allowed, relist after 2 weeks on a date to be fixed by the registry. However, needless to clarify that the return, considering that the area salary of the petitioner since 2007, for the period 2007 to 2021 has been, is due, comma, the return shall be positively filed by the next date of listing, if so advised.
Item 2.
The matter relates to compassionate appointment, his father was working as a superintendent in PWD department, His father expired on 19/6/2015.
Notice not issued.
No notice issued,
What, I said, what happened to the returns?
Returns. This is not
Long
filed,
back,
Lordship.
notice issued in April 2023.
Lordship. Yes, Lordship.
What has happened thereafter?
After September to 23.
Short affidavit of the state would be necessary for a just decision of the issue involved. This is a matter of May 25.
Yes,
What happened to that short affidavit?
Lordship, this is inadvertent
Hmm?
mistake, Lordship, it is not filed.
Every time on account of state not filing affidavit, matter is getting this. You file it on the next date, otherwise I'll
Yes,
have
Lordship,
the hearing
kindly
officer.
Allow 1 week time,
1
Lordship.
week, failing which the officer concerned shall be personally present in court.
Lordship.
This cannot go on like this. This is a compassionate appointment.
Right.
Compassionate appointment matter. Now you will take the stand. Oh, so many years have elapsed.
Yeah.
The entire issue has become infractious. Since 23, this matter is pending. Heard Mr. N.K. Kalita, Learned Counsel appearing for the petitioner, also heard MS M. Bhattacharjee, Learned Additional Senior Government Advocate, Assam. Stop. It appears that since issuance of notice by this court on 19/4/2023, despite several opportunities for filing affidavit having been granted, the affidavit has not been filed till date. Pertinent that on 19/5/2025, this court, having regard to the nature of controversy involved in this case, specifically directed the department concerned to file a short affidavit on behalf of the state for a just decision of the issues involved in the case.
Lordship, if it is department, Lordship, PWD department, they have to file, Lordship, because this has not been considered by the.
Whatever,
DSC,
both, I'll
Lordship.
say both parties.
Yes, Lordship.
And you are MS?
Yes.
M thus for respondent number 2, Standing Counsel PWD. Standing on it, so affidavit of respondents will be koidiba. By way, this court makes it clear that in the event the affidavits are not filed by the respondents by the next date of listing, i.e. at a date after 2 weeks, comma, the airing officials concerned of the stroke respondents shall be personally present in the court. What copy?
19.
Yes,
Here-
Mr. Bora?
Here also affidavit has not been filed, my lord.
My lord,
How much time, Mr. Bora?
my lord, that short affidavit you have received instruction within 1 week, I may file, I can file it. my
You have
lord.
received the instructions?
Yes, my lord. And
Okay.
otherwise, my lord, from the pleadings of the petitioner, my lord, it appears that he is not qualified. in
Anyway, you
particular.
put it
Yes, my
on,
lord.
you place it.
Yes.
Heard Mr. N.K. Kalita, learned counsel for the petitioner, also heard Mr. D. Bora, BORH, na?
Yes, my lord.
Learned Standing Counsel, Health Department. Mr. Bora submits that his office has received the instructions
Yes.
and accordingly seeks a short accommodation to place the same by way of an affidavit. Prayer is allowed, relist after
After 1 week, any day.
after 10 days or at a date, released on such and such date. You
Problem.
file it by then.
Yes, my lord.
This is sexual harassment.
Yes, my lord.
Yes, Mr. Bhattakur. Yes.
Petition prayer has been granted, my lord.
Granted.
Yes,
What was the prayer?
the internal complaints committee, my lord, was reconstituted. Earlier, there was a mistake, my lord. There was no woman member in the board. Now,
The prayer was for constituting a
Reconstitute.
for a that has been done.
Yes.
Mr. Kalita, are you aware of it?
Regarding constitution, I am aware, my lord, but what is the finding, my lord, that has not been communicated to us.
I'll file it then, my lord. I'll bring it on it.
Is the what has the committee done after being reconstituted? Have they have they completed?
Yes, proceedings.
Completed. But then you place it
I'll pay.
at 2.
I'll file an affidavit, my lord. 2 weeks.
Why affidavit? You give it if it has been done, then
my
you can dispose it of.
It is with me. I have the.
Then you do one thing, you show it to Mr. Kalita. Mr. Kalita, you have a look at it because your prayer is only for reconstituting the internal complaint committee as per so and so. More respondents more particularly so to take necessary steps as per guidelines for redressal and upon the response for non-compliance. Correct. So this is the prayer.
Yes.
Looks like it has been reconstituted. Looks like they have also given some orders. Now, whether even if you have some grievance, that would be a different cause of
So, my
action.
lord, may I pray, my lord, let him serve a copy on me, my lord. I'll consult with my client also.
What is
Let
that
it-
consult with the
Let
client?
it
as-
be on, my lord, Tuesday, my lord.
I don't think an affidavit is required.
Hello.
Isn't it, Mr. Bhattakur? It appears on heard Mr. N.K. Kalita, learned counsel for the writ petitioner, also heard Mr. I. Bhattakur, learned standing counsel,
For respondent 2, 3, and 4, my lord.
learned counsel appearing for respondent number 2, 3, and 4. The grievance of the petitioner canvassed in the instant writ petition is non-reconstitution of the internal complaint committee as per provision of section 4.2 of the Sexual Harassment of Women at Workplace within bracket Prevention, Prohibition and Redressal Act of 2013. Inter alia Billicode. Today, when the matter is called, Mr. I. Bhattakur so and so on instruction has placed the instruction dated.
Dated 5/6/2025.
Please give it 5/6
2020.
2025,
5.
whereby it is whereby it is seen that the complaint committee has been reconstituted to conduct inquiry on the complaint submitted by the petitioner, and the said committee, that said reconstituted committee, after obtaining statements from the petitioner and her few colleagues, has submitted its findings and has also recommended further course of necessary action. Stop. Let a copy of the said minutes dated 11/3/2025 along with the annexures submitted with the instruction dated 5/6/2025 be furnished to Mr. So-and-so Kalita for obtaining instruction thereof. A copy of the instruction so and so along with its annexures are kept on record and marked as A. If you want, you can give the photocopies. These are originals. The minute is the original that you have handed over.
If I may, my lord, have the
Yeah,
instructions
yes,
just for scanning, my lord.
Photocopy will be given. Photocopy is kept on record. Relist when?
Tuesday.
On such and such date.
Four.
Item number 5.
Mr. Kalita, you see, we don't know. Your client might,
My lord, as I am told, my lord, she was never called, my lord, that is.
but it says
Yes, my lord,
the
that-
minutes are there, and that is why I've
That is
said.
fine.
You see, the controversy in this writ petition is only this.
Yes.
So now, if you have further something, perhaps you might have to do it, raise it by way of another writ, perhaps.
Yes.
I don't know. So, all right.
Okay.
Yes.
May I please, Lord?
Yes, Mr. Barbhuya.
My lord, in this case, my lord.
Why were you removed from service?
My lord, he was, my lord, ailing, my lord.
Huh?
Ailing, my lord.
What?
Suffering from some ailment, my lord.
Ah,
called, my lord.
ailing.
Pneumonia. My lord, yes, my
Hmm.
lord. But he was a regular appointee, my lord, as a pharmacist, my lord. Long time.
Affidavits have been filed, Mr. Chotia, I think 24/9/25.
My lord, my lord.
Yes.
Yes, my lord.
Reply.
My lord, reply in this case, my lord, my humble understanding is may not necessary, my lord.
That is your understanding, but once the case is taken up for admission hearing, then if this court finds that your reply is necessary, no chance will be given to you. You want to
Yes.
take that risk, that is your call.
Yes, my lord.
I have not opened the brief.
Yes, my lord. With due respect, my lord, I beg to submit that, my lord. Basically, in this case, my lord, natural justice was not at all followed, my lord. And their affidavit also does reflect that natural justice was followed, my lord.
What has not been followed?
Because, my lord, for a departmental, my lord, inquiry, investigation, and my lord, departmental proceeding is necessary to remove any, my lord.
Nothing was done.
Nothing was done.
There was no inquiry.
Nothing, my lord.
There was no inquiry.
No shock was, my lord, no reply was taken, no.
This is admitted in the affidavit.
Admitted does not reflect so, my lord. It was done, my lord, it is not written, my lord, in the affidavit.
Where is your allegation that these are not done in your writ petition?
Yes.
কিবা এখন খুলিব পাৰিলে খুলক বা কিবা এটা দিয়ক because it's getting suffocated.
My lord, paragraph 5 onwards, my lord, I have stated, my lord.
So whether Mr. Das is not for the air condition, but with our dresses and with no ventilation, it becomes very suffocating. You know, and there are no fan this side also. I have started sweating.
Side where they could have kept open.
I don't know, but so bear with us. I've asked him to switch on the air condition for some time. Yes. Yes, where are your averments?
My lord, paragraph, my lord, 6 onwards, my lord, that the petitioner begs to state that respondent number 4 could not have released the petitioner in this illegal and arbitrary manner, my lord. It was proved in the departmental inquiry that the petitioner was suffering from schizophrenia. Therefore, he remains absence occasionally in his. The petitioner was never suspended and or departmental proceeding was initiated against the petitioner.
Where is the reply to this?
My lord, your reply affidavit, my lord, they have not.
Yes,
controverted.
yes, show me that paragraph. Temporary appointment.
No, my lord, it was, it is, my lord, written does, my lord, but he was.
Show cause notice issued. Submitted an inquiry report. Everything is there. Yeah, isn't it, Mr. Chutia?
My case is the termination simpliciter. My case is of termination simpliciter. No inquiry is also required, my lord.
But
And
I
it is
think
submitted.
some inquiry
Yes,
was done.
Inquiry was done.
Because your para 4, 5,
Yes, my
6
lord.
says
My lord,
it's all there.
my lord.
My lord, in this case, my lord, even my lord, any employee, my lord, for
They have done it. And their stand is termination simpliciter. Nonetheless, they have issued you a show cause
no, my
notice
lord, we have-
on 2/6/2015 pursuant to complaints received
my lord, it is,
that
my lord,
state that the in charge so and so submitted an inquiry report of a committee in respect of the petitioner, which revealed that the petitioner is suffering from so and so, that the unauthorized absence. Subsequently, petitioner was released.
yes, my lord, but he was not given any chance to, my lord.
Show cause notice, what was this show cause notice? 2/6/2015. 2/6/2015, Annexure 1 in the affidavit. You have not filed a rejoinder. We will take this. You don't want to file a rejoinder. The paragraph 5, it's there.
It is, my lord, something else, my lord, as per my understanding, my lord. This,
This is the show cause notice.
yes, my disciplinary
Show cause
action.
notice was issued to the petitioner
Yes, my lord, but there,
dated 2/6/15 pursuant to complaints received from so and so regarding the petitioner's unauthorized absence from duties.
yes, sir. Here, my lord, lordship, in their affidavit, page 34, my lord. Here, my lord, so explain why disciplinary action should not be initiated.
Yes,
But no such, my lord, disciplinary.
that's because termination simpliciter, where your removal from service.
Right.
But then how can you say it is termination simpliciter, Mr. Chutia?
To annexure to page
No, because you have removed him because he was unauthorized absent.
Lordship will look into annexure to page 15. Appointment order itself, my lord.
In every appointment, my lord, such a clause is there, my lord. I
What?
Place it, my lord.
In every appointment, my lord, they initially.
Place it, my lord, all the cases, case law, and I'm ready for hearing, my lord. The
Yes,
In-
what do you want to rely on page 15?
page 15, my lord, that he was appointed for a period of 3 months, my lord, from the date of joining of his service. And the last line, my lord, subject to production of medical fitness certificates without fail.
See, if you would have just simply removed him,
My lord.
there was no difficulty, Mr. Chutia. I understand what you're trying to say, but looks like you have removed him because he was correct. That order, Annexure 134.
My lord, you can look into the rules, my lord. Some pharmacy studies.
All right, we'll have it for final disposal on Tuesday. Heard Mr. A.M. Barbuya, Learned Counsel for the petitioner, also heard Mr. J. Chutia, Learned Standing Counsel, KAC, appearing for the respondent numbers 3 and 6. It appears that the affidavit in opposition on behalf of the respondent number 5 has been filed on 24/9/2025. Mr. A.M. Barbuya submits that no affidavit in
No, no,
reply. Yes, that was your submission. You want to change your submission?
No, not, my lord, I said, my lord, there.
Are you filed?
In the meantime, I may file, my lord.
Relist, then when do you want the matter?
My lord, next week,
Relist the matter, give,
Thursday, my lord. next
not
week.
next week, the week next Tuesday. Relist on such and such date in the for admission. In the meantime, the petitioner, if so advised, may file their reply.
Diplomat. Item 6.
Yeah, please, your lordship. On last occasion, your lordship has directed us to annex a legible copy of the order we have annexed with our writ petition, your lordship.
Yes.
And it was annexed as flag B, your lordship. We have submitted, your lordship.
What is this judgment?
This judgment, your lordship, our case is that this judgment has already decided the issue that we have raised in the present petition. It's
What
related
is the issue?
promotion, your lordship, whether your lordship, the petitioners will be included, your lordship, in the rule 3(1)(c)(4) of the relevant rules, your lordship, for getting the benefit of promotion, your lordship. That's the issue, your lordship. Now, the petitioners, your lordship.
You have seen a copy of this judgment? Is it covered?
Lordship.
Yes.
Now, your lordship will kindly see the present petitioners four in numbers, your lordship. They are appointed at your lordship various dates, your lordship. as your lordship instructor, your lordship petitioner number 1 as instructor social studies, petitioner number 2 as instructor social studies, and petitioner 3 and 4 as instructor English, your lordship, in the various ITIs of your lordship under the respondent authority, your lordship.
Yes.
And they have a length of service, your lordship, around in this particular post 28 years, 32 years, and 15 years each, your lordship.
Yes.
Now they are aggrieved by the fact that they have not been, your lordship, promoted till date, your lordship. And in spite of being, your lordship, eligible, and also, your lordship, the honorable court having held that they are entitled to be promoted, your lordship, based on Rule 3(1)(c)(4) of the rule in question, your lordship. And in fact, your lordship, before going
Yes.
further, your lordship, if your lordship, the facts before your lordship, just for a moment, your lordship, look at the rule, your lordship, which is
Well, I'll admit it and post it for hearing. Heard Mr.
otherwise, your lordship.
Because they are disputing that, heard Mr. Barthakur, that it's
If your
counsel appearing
lordship
for the
kindly go to the
petitioner.
judgment.
Also heard Mr.
SP does not.
SP
SP does.
Das Learned Counsel appearing for respondent numbers
2 and 3, my lord.
2 and 3, and Mr. D. Bora. For 1 and 2. Mr. So-and-so Barthakur submits that the issue involved in the instant writ petition is covered by the judgment of this, of the coordinate bench of this court dated 15/9/2014, passed in the case of Srimati Jyoti Maya Majumdar Das and others, versus so-and-so in WPC 3537 2012. However, Mr. SP Das, Learned Standing Council disputes the same. The legible copy of the aforesaid judgment has been placed before this court as per the direction passed earlier on 19/9/2025, which is kept as flag B. Perusal of the upon perusal of the aforesaid judgment, it appears that the matter requires a full-fledged hearing. Admit, relist for hearing in the first week of November, in the second week of November, on any date to be fixed by the registry. Yes.
My lord, today is Friday. I am prepared with the case, but not a hearing day. But these are matter of admission. Just 2 minutes, your lordship.
You wanted to
No,
be
I
disposed of at the admission stage.
That's right. Because this is a matter.
What is the issue?
My lord, I'll just put a very narrow compass the matter. All these petitioner before your lordship are stenographer grade 3 in this SCRT. So some are again district
In the
level SCRT, and some are working also at district level. So all the except petition number 23 and 24, all are appointed prior to that. As per revision of payroll, they were getting the grade pay. Now to petitioner 23-24, in 2023 by an advertisement they were appointed and they were getting a grade pay into as per revision of payroll 2017, 8,700. We are also getting 8,700. That's our particular case. In the meantime, one of the employee retired. Not this petition, some of the employee retired who were working in SCRT. So getting a grade pay of 8,700, they said, no. AG went to the office of the accountant general. They said, how 8,700? Revision of payrolls only speaks about one of the department, namely the secretary department. Only they are entitled to get stenographer grade 3. They are entitled to get only 8,700 by revision of payrolls. But notification of 2017 says it is applicable to all the departments of the state department. They are entitled to get 8,700. So accordingly, it was paid. But revision of payrolls, it only speaks about second department. Now government, that is why the AG takes a decision that no, one of the employee retires, they are not entitled to get 8,700. You are entitled to 7,400. Now, all the employees who are getting 8,700, all these petitioner, their grade pay was reduced from 8,000 to 7,400. We are aggrieved and we have come up before this court. There is an interim direction, you don't recover them. You don't recover them. Now, our case, all affidavits have been exchanged. Our case is only 1 point. You cannot create a class within a class. One, why?
You cannot create a class within a class.
It's an intelligible differential. Why? Simple answer in their affidavit. We have also other department. So far as stenographer grade fee is concerned, all are getting 8,700. This is the first point which we raised, 8,700. Number two, all appointment of grade stenographer grade fee are appointed by virtue of a statute. Same on the virtue of that statute, all are appointed. So where is a question that you have created a class within a class? There is no answer in the affidavit. In paragraph 3 of the writ petition, we have stated that when you are appointed under a statute, you have appointed others also under that same statute. There is no answer. They said we have no comment to say. Now they are now putting a shoulder or trigger on each other and saying, AG, the affidavit file, account agent says that no. What can I do? It's a ROP rules. Finance department is saying that is also same thing. Now what can we do? AG has said. SCRT said we can't say anything. In one of the reply, finance department has admitted, yes, under stenographer grade 3, it is entitled, but what we can do, it is the ROP rules. So this is our whole case, my lord. It needs some time to adjudicate this.
I think let's do it like this.
Yes.
You both side also, because I think you will be the
Yes.
main answering side.
Lordship, one in our affidavit, Lordship, we have stated that the notification and the
I'm
execution.
not hearing it right now.
Yes, Lordship, I'm just asked and.
And you know, Mr.
Yes.
Chulia,
Yes.
I shall not remember anything on the
Yes,
next
Lordship,
day. Yes. Yes.
The issue is all this correction
Mm.
has to be done by as per our affidavit, Lordship, it has to be done by the authorities in the GAD and SAD. This is as per our affidavit, Lordship.
Who is for GAD?
And GAD and SAD are not a party in this matter, Lordship. But in our affidavit, we have clearly stated that this
Like,
discrepancy.
we will hear them on
Yes.
the next day. We will see if the presence of GAD
Yes,
is
Lordship.
required,
The
if they are
council
necessary
for the
parties. Huh?
GAD is the council for the GAD is their stand, Lordship, because
They are here.
they are not a party, but my learned friend Mr. A. Fukon appears for GAD and SAD, Lordship.
Mr. Das, is GAD required?
Lordship, as per our affidavit.
You have, Mr. Das, you do it like this. Anyway, I'm going to post it either next week or the next week, Tuesday, Thursday. So if you want to,
We'll see.
by way of an IA, you
Yes.
place it,
No,
and if
we'll-
required, we
Should
will
we-
allow it.
in our-
It's just a formality.
Yes.
And you can have that amended cause title ready. It can be
No,
done.
If
If
necessary.
necessary.
If necessary,
Because
we'll.
in our affidavit, Lordship,
unless-
we have stated that this.
All right, you have said it.
Lordship.
They will examine it. Then it is before the court
Yes.
now to see
Yes.
whether they are necessary or proper
Lordship.
parties.
Lordship.
And whether non-including them would defeat the whole petition.
Lordship.
What more can be done at
Yes.
this stage, Mr. Cholia? We
Yes.
cannot force
Lordship.
the petitioner to add them if
Lordship.
they are not willing. Can we do that?
No.
And if you both side is agreeable that on the next day the matter is going to be disposed of, then you have a small
yes.
written synopsis
Yes.
prepared.
Yes, we'll do it. We'll do it.
Ask your junior to
Yes,
get
yes.
that ready. Heard Mr. Didas, Learned Senior Counsel, assisted by
Our sense to us.
R. Senswa, Learned Counsel appearing for the petitioner. Also heard Mr. A. Chalia, Learned Counsel appearing for
Finance, respond 2 and 3.
Standing Counsel Finance Department, and Mr. R.K. Talukdar, Standing Counsel of Accountant General, and A. Fukan, Respondent Elementary Education, in bracket respondent number 1. You are for R5MS A. Bhattakur. It appears that the matter requires a detailed hearing. However, the parties, considering the urgency involved in the writ petition, has agreed for a final disposal at the admission stage. Relist when? Tell me a date
I think it's better that you spill over to next. 11th is better.
on such and such.
11th
date.
is a Tuesday.
In the meantime, the parties are at liberty to submit written
Yes,
submissions
better.
if so advised.
Actually, it should, his sister and friends should be, but I feel.
Yes, because it's
There's-
easy then.
Whenever a matter comes up, prior to 2 days, it should be handed over to.
Absolutely. At one point,
So-
that was a
Yes,
trend
we
for the
used to
hearing
give-
matters.
Normally,
Because
hearing-
you see, the idea is to facilitate the judgment in the open court, delivery of a judgment. Now, if we have that written thing and everything is there,
Well,
it's easier to.
first thing when we address, we go to a senior counsel, he said, where is the list of dates?
Correct.
That was system.
Now, I remember at one point the written submissions was also made compulsory
Yes.
for all hearing
Yes.
matters. I forgot at which during whose time, but
Yes, yes.
for a
Written
brief time it
submission
was
was- yes.
there.
But
Anyway.
list of dates was mandatory.
That is to always there, but the problem is you
Mandatory.
see that those list of days are part of the brief. So during hearing stage, the matters become so voluminous
Yes.
that list of date is not very helpful.
So it's a note,
Actually,
like
correct,
in the
correct.
Supreme Court we see, it's a notice given, from both the side notice given.
Absolutely.
And to the point. Point 1, point 2, point 3, and these are
It helps.
the issues that it helps.
It helps.
That is why big matters within.
Yes, because you see, otherwise we end up flipping pages and finding out
Difficult.
those relevant pages and documents, the dates.
Of course, yes.
Correct.
deeply obvious.
May I please your lordship? In this matter, the petitioner was teacher of Sanskrit in a high school, my lord. He was appointed by the school managing committee in the year of 2004, my lord, and his service was approved by the inspector of school.
Affidavits?
Yes, your lordship, you have filed
Affidavit
it.
have been filed. The petitioner school was provincialized in the year of 2013 under the 2011 Act. At that time, his service was not provincialized. After fulfilling all criteria. Thereafter, the inspector of school submitted the relevant document of the petitioner before the district school scrutiny committee Lakshmipur, but that was not forwarded. Thereafter, the said act was no longer exist, a new act has 2017 Act has come. In 2017, he was again submitted the relevant document, but this time he was also left out. Because that under the rule, the 3 consecutive year, that is 2014, 15, 16, the minimum 10 students should be appear before the last 3. In 14, there is only 4 students.
Now 10.
Now, the 16, 17, 14 numbers of student appear, 16 numbers of student appear, and day by day they are increasing milestone. But his service was not provincialized, and the similarly situated left of Sanskrit teachers, they have approached before this honorable court, a batch of which petition was filed, and after hearing the matter, that matter was finally disposed of, my lord. I have annexed that order. In view of that order, the petitioner should be get relieved, my lord. That is case 36. The order start, my lord. And in the start, and in paragraph 5, my lord, if I am permitted to reading page 39.
Yes, please.
Page 39, paragraph 5.
Drawing attention.
Drawing attention of the court to the schedule of the act prescribing the maximum number of employees per educational institution whose service can be provincialized. Learned Senior Council has submitted that in a high school, high madrasa 2 class, it is obligatory to provincialize 1 classical teacher. It is submitted by him that the concept of number of students as sought to be introduced for the purpose of provincialization of a classical teacher is misconceived, as there is no requirement under the provision of the Act that unless a particular number of students are enrolled in a particular subject, it would not be permissible to provincialize the service of the teacher of that subject. All that is required under the provision of section 3(2) of the Act. It contains minimum number of enrollment for the school as a whole, and admittedly, as the school of the petitioner has fulfilled the minimum requirement of enrollment of students, the school were provincialized. He has also submitted that the respondent has acted in a discriminatory manner on ethic and choose basis in provincialize the service of Sanskrit teachers in some schools.
Here the subject is what?
Sanskrit.
Sanskrit only. In your case also?
Yes, also.
Sanskrit.
My petitioner is a Sanskrit teacher. And after that, this court has given the.
No, you continue reading.
Yes, as the school of the petitioner has fulfilled the minimum requirement of the enrollment of students, the school were provincialized. He has also submitted that the respondent has acted in a discriminatory manner and a pick and choose basis in provincializing the service of Sanskrit teacher in some school, while not provincializing the service of many other schools like the petitioner. He has drawn the attention of the court to the affidavit in reply to contend that although no student had appeared in SSLC examination in the subject of the Sanskrit from Doniopolo High School, Gogamukh High School and Pandwa High School for the year of 2009 and 2011, immediately the proceeding for provincialization of the afforded school, the service of the Sanskrit teachers in those schools had been provincialized. Mr. U.K. Goswami, Learned Standing Council Education, Secondary Department, relying on paragraph 9 of the affidavit in opposition, has contended that as no candidate are appearing in the HSLC examination in the subject of Sanskrit, there cannot be any justification in provincializing the service of the petitioner. Paragraph 9 of the affidavit reads as follows. Paragraph 9, that with regard to the statement made in paragraph 6 of the petition, the deponent respectfully state that the Secretary Education Department requested the government by letter dated so-and-so 19 to 2013, the Director of Secondary Education Assam to examine the petitioner as representation dated 16 to 2013 and submit a report to the government of Assam. Accordingly, the Inspector of School Dhemaji has been requested by the Director by letter dated so-and-so on 26 to 2013 to submit a report of 11 numbers of Sanskrit teacher. Out of 11 numbers of Sanskrit teacher, there is no student appeared in HSLC examination. In 6 numbers of school where are 6 numbers of Sanskrit teacher. The report has been submitted to the Government of Assam Education Secondary Department after.
Right, I have read it. Now tell me, in your case,
Yes, my lord.
you have been left out.
Yes.
On the ground,
In 2013, there is no ground.
there was no
No
ground.
ground.
Then,
In
then the act got
2007.
repealed
In 2007, under 2017 Act, he was left out only because in 2014, there is only 4 students and 16
but that is 4 students in the Sanskrit.
Sanskrit.
But as per this judgment, the criteria is not about how many students enrolls,
This is the
as long
subject.
as that subject is there.
Yes, my lord, yes.
Correct?
Yes, correct, my lord.
So in which paragraph do I find the stand of the state respondent in their affidavit?
That affidavit.
Yes.
Page 48. Paragraph 5.
One of you may read it, please.
5, 6, 7. That's answering the opponent Hamzil Beg to state that as per the provided sections 4 to 4 of the Assam Education.
Just 1 second. Let's see from 4. Para 4. You read from para 4.
Yeah, the answering deponents humbly beg to state that the enrollment of students in the subject of Sanskrit in Borna Harani High School District, Lokhimpur is as follows as per report received from the Assam State School Education Board Division 1, your lordship. Here in 2014, there is 4 numbers of students, in 2015, 16, and in 2016, there is 13 numbers of students, your lordship. And a copy has been annexed, your lordship.
Now, under the amended, you have given a minimum number of students. In the case which is sought to be relied, there that provision was not there. Correct? Now you have brought in, and this provision is not under challenge. Then,
No, my lord.
because you see, under this, it says, in case of, this is as per section 424.
424,
Yes,
your lordship.
Correct, of 2017
Yes.
Act,
Yes.
as amended in 2018.
Yes, my lord.
In case of teachers and or tutors of the schools for special subject like Sanskrit so and so, the number of students
Yes.
appeared in the concerned final examination like HSLC and HS conducted by SEBA or so and so as the case may be, shall not be less than 10 students. So a minimum student is 10
10
in each class per year during last 3 years.
last 2 years.
So this is the
Criteria.
criteria. Now the question is whether you fulfill that criteria.
Yes.
So let's read para 6.
That the deponent humbly begs to state that therefore it appears that the enrollment data of students of Bornahari High School does not fulfill the section 4(2)(4) of the Assam Education's provincializations of service of teachers and reorganizations of educational institutions Act 2017, Your Lordship, as
Yes.
amended in 2018.
Then 7,
Here,
that
that is
moreover after
answering-
verification.
Moreover, after verifications of authenticated records, it appears that the name of the petitioner, so and so, is not been reflected in the year 2016, which does not fulfill the 6 years continuous service in the concerned school, that is Bornaharani High School District, Lokhimpur. The petitioner, that is so and so, does not fulfill the criteria laid down in the section 4(2)(3) of the Assam province, it should be 4, Your Lordship, of the Assam Education.
Two? It should be what?
4, Your Lordship, section 4(2).
4(2),
Of
Se-
the Assam province.
not 3. That Roman 3 is not there.
Roman is there. my lord.
4.3 is there, Your Lordship.
No, but in paragraph 7, it should be section 4(2)(3) or only 4(2).
4(2)(4), Your Lordship.
4(2)(4).
Sorry, Your Lordship.
4(2)(4). Okay.
Of the service of the teacher and reorganizations of educational institutions Act 2017 as amended in 2018.
Yes, ma'am.
Yes, my lord, but petitioner was left out in 2011, my lord.
Yes,
And-
but Ms. Bajar Barua,
But
now-
similarly situated
now,
person was already been appointment.
correct, but now under the new rules.
So let
Why
us-
was the petitioner left out earlier?
The criteria which had not been fulfilled by them, Your Lordship.
No, but where have you said that in your
Yes.
affidavit as regard the earlier
At that time,
2013 time when it was provincialized?
at that time that there is number of students.
Where is that affidavit? Where is your stand in that, about that in your affidavit?
No, my lord, there is no stand.
Because had you considered the case of the petitioner fairly at that time, perhaps the petitioner at that time would have qualified because there was no, that rule was not there at that time.
Your
This has subsequently come. Now, this is which paragraph in your writ petition you have said this?
Yes.
Yes. Paragraph 8.
Ne-
So why was petitioner's name dropped?
Paragraph 7, that your petitioner beg to state that the government of Assam for the purpose of provincialization of Bhansar school and colleges call for the detailed particular of teaching and non-teaching staff from Bhansar school.
Yes, where are your response to para 7 and 8? You see, they're part of the pleadings. This
Yes,
court
Your
will have to answer this issue also. Because if suppose at that time they were qualified under those rules, then a discrimination has been done. If you have just dropped them for no reason, you cannot pick and choose. I understand. As per the new rules, now they are not. But when you had done it, as per 2012 rules at that time, when all the other staff was provincialized,
Yes, ma'am.
why was the petitioner dropped? Where is your response? The problem is you people do not, now a trend is being set where instead of filing a para-wise affidavits, short affidavits are placed. This is the reason. Where is the denial to para 7? Otherwise, I will say this is admitted and I will give my decision.
Give us a time so that.
I see there is no difficulty. I'll give you the time. But what I am trying to tell you is that because of all these technicalities, these courts are not being able to dispose of matters.
In 2012.
You see, because affidavits are filed for what reason? To bring clarity in the matter. There is a manner for filing affidavit. Procedures are laid down. The affidavits are nothing but rebuttals and your explanation. Where is your rebuttal to paragraph 7 and 8?
Yes, ma'am.
Rebuttals are not there.
And paragraph 8, yeah, I have.
You only pick up what is convenient and you put it in an affidavit, and that becomes the affidavit in opposition. Then when a time comes, the matter goes back to square one, when again you'll have to put it in an affidavit. It's only delaying the matters. Pendency rates are getting higher day by day. How can these matters get disposed of like this?
A short date, your lordship.
But this is a my lord covered case as this the owner.
Yes, but you see, covered case I understand, but subsequently that has been brought in. That part of the rule is not under challenge. But however, if this court finds that that time they had arbitrarily dropped you,
Yes, ma'am.
then this court can grant you the relief.
Yes.
But today,
absolutely.
in the affidavit in opposition filed way back in 2000, there was this file in July 25. There is no whisper to paragraph 7 and 8. Again, whisper, they have not even denied. It's just a general denial in paragraph 2, and from paragraph 3 they have said the deponent at the very outset humbly begs to state that instead of giving parawise reply to the writ petition at this stage, deems it appropriate to disclose the stand of the respondents. What are these new trends that has been developed in the court? These are new trends that has been developed because of these kind of affidavits. Matters are not being able to disposed of. This is not the way of drafting affidavits in court. Heard Mrs. A. Burjar Baruwal, learned counsel appearing for the petitioner. Also heard MS
H. Terang PLS.
H. Tarangpi, learned
Standing Council Education.
standing counsel education. Stop. Anyone from finance? Mr. H. Mr. H. Chelia for standing counsel finance. The case of the writ petitioner is that despite the writ petitioner being qualified for his service to be provincialized at the time of the petitioner's school being provincialized under the Assam Venture Education Institution within bracket Provincialization of Service Act 2011 as amended on 2012, comma, was arbitrarily dropped out despite provincializing the services of all other staff, right? All other staff on 1/1/2013.
The
Stop.
order was passed on 22/9/2014.
It's all right. It is the further case of the petitioner that thereafter this was repealed, this entire act. Which paragraph you've said this part? About the new act?
Same paragraph in our,
This is 12.
but in the bottom of but in the meantime, earlier Act 2011 Act was no longer.
Thereafter, it is specified that even after the new act was introduced by the Government of Assam Education Department, i.e. provincialization of service of teachers and reorganization and educational institution act 2017 it was Sailoba naam to, comma the case of the petitioner was not considered for provincialization. In the affidavit in opposition filed on behalf of the state respondent, on behalf of respondent number 3 on 29/7/2025, instead of filing the affidavit as per the provision of law, whereby rebutting stroke denying the averments made by the petitioner, pairwise in a pairwise manner, and instead chose to selectively place its tent. It appears that while doing so, the state respondent in their affidavit, though have explained the reason as why the petitioner was not qualified under the 2017 Act, however, is silent as regards the allegations of the petitioner, as regards the categorical allegation of the petitioner to the effect that the petitioner was discriminately and arbitrarily left out from the list of provisionalization in on what was that date? On 1/1/2013. While deprecating the manner in which affidavits are being filed in this court, however, this court grants a short accommodation to the respondents to place a detailed affidavit in the manner prescribed in law and place its stand before the court, covering the issue of dropping out the petitioner or from the list of provincialization on 1/1/2013. Yes, when do you want it?
After 2 weeks or not? After 2 weeks?
Relist on such and such date after 2 weeks, and the date so and so. It is needless to be clarified that because of such affidavits being filed in casual manner, this court could not dispose of the matter at the admission stage.
Master.
Yes, one second. Yes, Mr. Saikyam, you want water? Yes.
This to suspension, my lord. The petitioner with lordship was placed under suspension on 28/6/2024.
Affidavits have been filed?
My lord.
But pursuant to the last order dated 24/10 last week, we were supposed to file our affidavit. We are going to file it within the course of the day.
You're filing it?
Yes, Lordship.
All right, we'll have it next week.
Lordship.
Let them file it.
They are taking time for time.
But Mr. Saikya, he's filing it today. So I'll have it posted on Monday or Wednesday.
Any day, Lordship.
Monday or Wednesday?
Monday.
All right. Heard Mr. I.S. Saikya, Learned Counsel for the petitioner. Also heard Mr.
M. Bhuya, Lord.
M. Bhuyan, Learned Counsel, appearing for
It will be Health Department, respondent number
Health
2.
Department, na?
Yes.
Appearing for the Health Department, and Mr. D. Bora, Learned Government Counsel for the state respondent. Mr. So-and-so submits that the submits that the affidavit as was sought to be filed as per the last order dated 24/10/2025 is going to be filed within the course of the day. In view of the aforesaid assurance, relist on such and such date.
Good.
Item number 12.
Yes, Mr. Patwari.
The 8-year-old girl child.
Hmm?
Petitioner before your lawsuit is an 8-year-old girl child. And my lord, she was a lone child of her parents, and unfortunately, she is also the lone eyewitness of her mother killing her own father. And the mother is now behind custody, my lord, and the trial is going on in the murder case. Now, my lord, as the petitioner's father was a government employee, under Rule 143 of the 1969 rules, a minor child is entitled to family pension.
Rule 143.
143, Lordship may peruse mine.
It's all right. You just first
Yes, yes.
just say what you're saying.
Yes. Now, since the rule permits for family pension of a government servant to the widow or to the minor children, my lord, she applied to the authorities concerned. That is the Water Resources Department, Executive Engineer Dibrugarh.
When did you apply?
My lord, that data I don't have, but
Anyway.
the response I have annexed at page 51.
Yes. Then what happened?
My lord, the Executive Engineer Dibrugarh Water Resource Division on 5/2/25 at page 51 says that since the widow is also there, now either you have to obtain an NOC from the mother or you get an order from the court. That is at page 51. So, my lord, since the petitioner is the lone eyewitness, the page 51, my lord, last page of the writ petition.
Yes. Yes.
Last para.
Yes, I have seen it. Yes. It is to inform. Yes. Then
My lord, in view of this, we have approached this honorable court praying for family pension because the petitioner being the lone eyewitness, she has already deposed before the learned trial court against her mother. So, my lord, getting an NOC from the mother is out of question. Now, my lord, I am only praying at least 50% of the family pension should be, and this honorable court might order dated lawsuit kindly peruse 10/4/2025. Directed for release of.
just one second. এইটো কমাব নোৱাৰে নেকি? আমাৰ ইয়াত এইটো নাই না? A minute, it can be put in 26 or something, 25. একদম ইমান height কৰি থলে ফেনখন কমাব নোৱাৰে নেকি? It's very difficult to work in such condition, you see, because if you turn off the air condition, the room becomes suffocation. It's suffocated because there are no ventilation. And now the moment, and there is no control of the air condition in these rooms. So it is all done in the control room, and I don't know in what what setting they keep it. It is, as you all are, I'm sure you all are getting freezed that side also. It's very difficult.
48 of the writ petition.
Page
48, 48.
48.
Yes.
Court manager of Matov. Page
48.
48. What do you do? What do you do?
So this is the certificates certifying that the petitioner, and when the writ petition was filed, she was studying in class 2. Now she has been promoted to class 3, and she is living with her court-appointed legal guardian. Now she will kindly turn to.
She is living with her court-appointed.
Page 47.
You wanted to refer to some order of the court. Which was that order?
10/4/2025.
10?
10/4. This honorable court directed for release of family.
10?
10/4, my lord, 10th of April 2025.
10/4. That order is okay. It's kept here.
last part and.
To release the provisional amendment to the petitioner. Why this is not done?
And your lordship order 18.
One second, it's already, there is an order. Concerning the matters in its entirety in the interim, it is provided that the respondent are ready to release the provisional family pension to the petitioner. That is not done.
Your
This
lordship
order is of April 25.
18-8 order.
This April 25.
My lord, in terms of the 10/4/2025 order of the Honorable Court, my lord, we have submitted the proposal, my lord, before the, my lord, Treasury, my lord. Treasury objected, my lord, because Treasury said.
Who is the treasurer to object to the orders passed by this court? After that, have you filed
No,
an
Treasury
clarification? Because you see the 10/4/25 doesn't say considering. Please read the order of this court,
My lord.
10/4/2025.
Treasury not objected the getting the pension. Treasury objected that there is a certain formalities that have to be followed, my lord. Therefore, my lord, we submitted the proposal, my lord, of 23/6/2025, my lord. Then Treasury, my lord, says.
As per that proposal, apparently an NOC from the mother is required. Correct?
My lord, my lord.
Now, how can it be expected that the mother is going to give an NOC when the daughter is the sole eyewitness to the crime with which the mother has been alleged with and is inside and a criminal trial is being pending for which she is in custody?
No, my lord, considering that, my lord, that it is.
Next order, Mr. Patwari.
Your lordship order 18-8. Very unfortunate.
18.
18-8, your lordship order.
After 18/8, what happened?
Well, 18 on 29 it was listed, there, the.
Some
mother-
difficulties in releasing.
Yes, and my lord, then again on 22.
And these difficulties have been placed by way of an affidavit.
No.
No, my lord, we have received instruction, my lord. That's,
But why is this affidavit not forthcoming?
and we will file.
For whose permission is this affidavit being kept pending?
My lord, within 1 week, we will file.
No, but why that affidavit has not come? Because you see, I am not on you may be right. You may be right that you have to follow the law. There may be certain procedures. I am not saying they are not. The whole issue is that you see, when matters come before the court, one has to also have some empathy,
My lord, absolutely.
right? Litigants just don't come to court. Nobody wants to come to court, and especially a minor child whose mother is being charged for murdering her own father. Can you see the trauma this child is going through?
My lord,
And now she is entitled for family pension under the law. The same is also not being released despite orders of the court for formalities, technical formalities. All right, they are there, but there has to be a solution. Why the affidavit is not being placed before this court when there are judicial orders of the court?
within 1 week, my lord, we will file. And also.
There is no
alternately,
problem
my
in
lord,
giving you the time. The problem is the casualness. That has become the matter of routine before the court nowadays.
I apologize for that, my lord, because we have.
It's too casual, these kind of attitudes.
My lord,
Absolutely unacceptable by the constitutional court.
No, my lord, that is also happened because we had 2-3 times we have take up the matter with the finance department, my lord. Treasury also. Then some. my
You
lord,
see,
yes, also there.
I understand,
Leave, my lord.
but you see, I am not saying, whatever you're saying, I'm agreeing.
My lord.
But what I'm trying to tell you is that there are certain ways. Why these ways are given a go by? I'm not saying you may be right in whatever you're saying. You're having difficulties, you file an affidavit, the court may come up with a solution. The idea is to solve the problems, not to linger the problems,
My lord, absolutely. My lord,
the traumas of these litigants. Why to keep them hanging? These are not matters to be even come to the court or kept pending before the court.
my lord, I just like to, one submission, my lord. Because, my lord, initially we can find the affidavit in that light, my lord. Subsequently, we are doing more than that because we are personally talk with the finance department that this is the court order and this is the procedure. Not now, how can we go forward, my lord? Then, my lord, finance department said that after that, my lord, then proportionate to my lord, some GIS leave encashment that can be released, my lord. But subject to the permission of this honorable court, if honorable court said that regarding the particular pension, my lord, that has some procedural difficulties, my lord. Therefore, we have.
So what can be released?
My lord, GIS, my lord, leave encashment and gratuity.
No, but why there is a problem for the provisional pension?
No, because my lord, provisional pension, we are the administrative department. We can only submit the proposal because the finance
Who is
department.
appearing for the finance? Where is Mr.
That-
Telia?
Right.
Is finance a rate
My
respondent
lord,
here?
it's the accountant.
Yes, ma'am.
Finance is a respondent here?
No, my lord,
No, ma'am.
accountant.
Accountant general is the
Who is appearing for,
Accountant.
where is Mr. Talukdar?
Accountant. general.
No, but who is the treasurer? Who is creating all these difficulties? Who is appearing for the treasurer? We'll have the finance then added.
Lordship will permit us to implement by the.
I think we'll do that first. I'll have this matter fixed again on Monday. We'll add the finance, or we can have the matter.
My lord.
Uh,
My lord, is the director, accounts and treasury, my lord.
yes, but that ultimately the treasurer is the person. He'll fall under the finance department, right?
My lord,
Now these formalities has to go through.
my lord.
Heard Mr. J. Patwari, Learned Counsel for the petitioner. Also heard Mr.
Peace again.
P. Saikia, Learned Counsel appearing for respondent numbers
My lord, water resource department.
for the Water Resource Department.
Well, I am for the respondent.
Mr. Islam, na? R. Islam, Legal Aid Council
Yes, legal.
for the respondent number 5. R5 is the mother.
Yes.
Already filed it. I have already filed it.
You have an objection?
Yes, ma'am. I have objection on that ground because the pensionary benefits entailed is both for the
All right.
child and the spouse. So.
So
some portion-
50%.
Yes, some portion, if released, I have.
So
nothing.
if that is
So
your,
we can-
I can dispose this by saying 50%.
My lord, that can be also.
That can be also done.
My lord.
Then will any technicalities
If
come?
She has no objection. Because of
No,
consent.
no, that is there. The affidavit is there. 50, which page?
But I have not written here 50%, mother.
No, but you've said, in other words, you have said it. So let us see what exactly you have stated here.
Mother,
Affidavit starts from page 52. Running page 52.
Now, where have you said it is for both of you?
Mother, para 6, mother. In the middle portion, mother. The pensionary benefits are meant for the welfare of the both child and the surviving spouse, and not to be handed over unilaterally to the relatives under the guise of the guardianship.
So that's all. So I think then to be fair, we can say 50%.
Yes.
You're agreeable to
Yes,
that?
But in case of the provisional pension, that may be 50%.
Yes,
Others-
provisional pension only right now.
Yes.
It is final pension.
Provisional family pension.
Family.
Yes.
Not
Okay,
the
Mr.
others,
Patwari.
the encashment and retirement benefit that will.
I'm not saying anything about anything else. I shall dispose it
Yes.
off simply on the basis that in basis of the affidavit, paragraph 6, we will
Yes.
quote it.
Uh.
It appears that nobody is disputing that position right now.
Yes,
He is not saying that give me the entire.
yes,
You are also saying that no, I don't want the entire.
yes,
You are being fair, saying that no, it is not meant for
yes.
the child alone or for you alone.
Yes.
It is meant for both.
Both.
In fact, my
Yes.
lord, that submission may be.
I will record. I will
No,
record.
no objection.
I'll record. I'll record. Everything is on live streaming.
Yes.
I'll record it.
It may be considered.
Heard Mr. J. Patwari, Learned Counsel appearing for the petitioner. Also heard, ich need to coerce, no? Sorry. By way of Article 226, by way of this petition under Article 226 of the Constitution of India, comma, the petitioner is seeking
Page 13, my lord.
Yeah, I got it. Is seeking release of the family pension of the deceased father of of the deceased father, late Madhurya Barua, in favor of the petitioner with effect from 10/9/2024. Inter alia query, huh? The case of the petitioner is that the case of the petitioner is that she is the daughter of late Madhurya Barua and respondent number 5 and is aged about 8 years as on the date of filing the writ petition. It is the case of the petitioner that at the time of her father's demise, he was working as the section assistant in the office of the executive engineer, Dibrugarh Water Resources Division at Dibrugarh, Assam. It is the further case of the petitioner that her father was killed, her father was being murdered, for which initially an FIR was lodged before the Chabwa police station by the respondent number 5, alleging that some unknown miscreants on 10/9/2024, no, don't say that data, had killed her father. However, later on, upon investigation, upon information, no, upon finding that it was respondent number 5 allegedly who has killed her father, a subsequent FIR on 14/9/2024 was filed by the police authorities against the respondent number 5, which was registered and numbered as Chabwa PS case number 70/2024 under section 103/3238/3 within bracket 4 of the BNS, corresponding to Dibrugarh Sessions case number 354/2024. Thereafter, the respondent number 5 and other accused persons have been arrested and are in custody in Central Jail, Dibrugarh. Since under the rule (143) of the Assam Services Pension Rules 1969,
Para 10 we have quoted, my lord.
huh?
At para 10 of the writ petition, we have quoted the rule.
The family of the deceased government employee is entitled for family pension, comma, the present writ petition has been filed. Correct? Stop. Mr. So-and-so Patwari submits that despite this court on the date of issuance of notice, I 10/4/2025, after considering the matter in entirety, having provided in the interim for the respondents to release the provisional family pension to the petitioner, comma, the same has not been done till date. Drawing further attention of this court to the, where is that NOC thing you said?
Yes, my lord, last page of page 51 of the report. Last page of the report.
To a
Last para.
letter dated 5/2/2025 issued by the Executive Engineer Dibrugarh WR Division Dibrugarh, wherein it is informed that in order to release death benefits of deceased petitioner, a deceased father of the petitioner's deceased father, comma, under the rules, NOC from the other next to kin is required, comma, he submits that since the petitioner is the sole eyewitness to the incident, that happened on the night of 10/9/2024, when she suddenly woke up from her sleep and saw her mother, I respondent number 5, with the help of the co-accused, I brother of her Bihu dance teacher, assaulting her father, which resulted in his death, comma, the requisite NOC is not being provided to the petitioner.
By our fine.
Is not being provided to the petitioner by the respondent number 5. He further submits that since under the relevant rules, the petitioner is entitled for the family benefit of the family pension as provided along with other surviving next of kin, 50% of such family pension may be directed to be released. Stop. Per contra, Mr. So-and-so, learned so-and-so, submits that due to the difficulties in releasing the provisional pension, comma, in view of the fact that the requisite NOC from the respondent number 5 could not be obtained, the interim direction passed earlier by this court on 18/8/2025 could not be effectuated.
10/4/2020. Interim direction.
Sorry.
10/4/2020.
10/4/24. He, however, fairly concedes that since under the relevant rules, the petitioner is entitled to 50% of the so and so along with her mother, i.e. respondent number 5. In the event this court deems appropriate, the instant writ petition can be disposed of by providing 50% of the family pension, provisional family pension. Provisional family pension. So I'll use the word provisional family pension. Okay. Okay. Provisional family pension. To the petitioner. Stop. Mr. Islam, so and so legal aid counsel for respondent number 5, fairly submits that in the event 50% of the provisional family pension is released to the respondent to the petitioner, comma, the respondent number 5 shall not have any objection, inasmuch as the stand of the respondent number 5 is that both of them, as per the relevant pension rules, are entitled to the family pension. Correct?
Yes.
Stop. Heard, perused, huh? Apt at this stage to refer to the relevant paragraph of the affidavit in opposition filed on behalf of the respondent number 5, which reads as under 6 to Didiba, quote unquote. Having heard the learned counsels appearing for the parties and having perused paragraph, above paragraph, where is that rule? And Taragot it rule to quote Koridiba.
143, I quoted also at para 10.
Para 10 or plus, I rule to quote Koridiba. Having perused the averments made in the pleadings as well as the affidavit in opposition filed by the respondent number 5, and keeping in mind rule 143 of the so and so, wherein whereafter the undisputed position that arises is that in the facts and context of the present case, the petitioner is undoubtedly entitled for 50% of the provisional family pension.
At present.
Considering that in so many words, the respondent number 5 has not objected to the same, as is evident from the averment of the affidavit in opposition extracted herein above, I am of the considered view that this writ petition in the interest of justice can be disposed of by directing the respondent authorities to forthwith release the provisional family 50% of provisional family pension to the petitioner through the guardian or
Yes, my lord, there is a court-appointed legal guardian.
through her na?
Yes,
through her court-appointed guardian. With anything more?
Yes, lordship, that legal guardian order, court's order I have annexed, my lord.
No. In this direction, anything else to be given? Huh?
Because the Captain General has nothing to do with
So who will be the respondent?
We will send the proposal, my lord, 1, 2, and 3.
Then respondents, more particularly respondent numbers
1, 2, and 3.
1, 2, and 3. It needless to clarify, who is going to send the proposal?
Proposal we will send.
Respondent?
Respondent 1, 2, and 3.
And then
send, my lord.
3 will
3
send.
will send, my lord, on behalf of 1, 2, and
3 will send to whom?
to the finance department, my lord.
Needless to say that
Captain
once
General.
the proposal is received by the finance department from the respondent number
1, 2, and 3.
1, 2, and 3, the same. Yes, anybody from finance is here?
That have to, my lord, proposal we have to submit before the accountant general, my lord.
Mr. Counsel, please sort it out. You see, I do not want any procedural difficulties anymore for this child. What has to be done should be done. You all are the department councils. Sort it out. It is one. It's all. All these departments are under the same state. So please sort it out and ensure that the whatever is to be given is given to the child. She suffered a lot. Yes. কি লিখে, sir? No, it is needless to be clarified that the respondents at all departments shall cooperate and coordinate with one another to ensure that the 50% of the of the provisional family pension as granted by this court shall be immediately without any further delay within a period of 1 month from today be released to the petitioner.
Deeply obliged, Your Lordship.
Disposed of. Yes, where is the court manager? No, Mata nai kya? Main matibo disu na.
Item 14.
Please, Your Lordship, matter may be passed over the time being, Lordship.
Item 15.
Made please, Your Lordship.
Hey, Bob.
Court appointed for the deliver yeah, deliver in order to court appoint.
Yes.
Yes. Lordship here.
This is item?
15.
Yes, Mr.
MH Loskar.
Locker. Yes, Mr. Loskar. What is this case?
Lordship, in this case, the petitioner who was serving as a manager, Your Lordship, he was transferred in between on 6/8/2025 to another region in violation of the transfer policy and also not considering his representation in accordance with the appeal. That was placed, that has been challenged before this honorable court. Now, Lordship would kindly consider that the opposite side is the Assam Gramin Vikas Bank. The petitioner, he was appointed in the present place of posting. He was there on with effect from 23/5/2022. Now, after his posting, a disciplinary proceeding was initiated against him. He was placed under suspension. He was not there in the service for about 16 months. Thereafter, an award of penalty has been imposed upon him. He has accepted the penalty and he was doing his service at that time. The improved transfer order was issued.
So you are challenging the transfer.
Transfer order, Your Lordship. Now, if Your Lordship sees the transfer policy is there, which is at page number 22.
Are you alleging violation of transfer policy?
Transfer policy and that some malafide is there. Otherwise, why
Have you pleaded malafide?
I have pleaded malafide.
Have you against whom?
No, I have not because they are the departmental
So
authority.
malafide has to be established in transfer matters.
That is correct.
You have not arrayed anyone.
No. Now, if Lordship takes up the transfer policy at page 22 for a moment, Your Lordship.
Page
22. The transfer policy of the department.
Yes.
Now, one of the objective is that to maintain transparency in the matter, this transfer policy has been initiated. Now,
to maintain
transparency in transparency in the transfer process.
Yes.
This is a transfer policy itself. If Your Lordship sees page number 24.
Yes.
It provides for a transfer timeline.
Yes.
Transfer exercise may be completed within June every year based on the tenure completed by officers.
These are not statutory guidelines.
Correct, Your Lordship. That I
These are
yes.
executive administrative
Yes.
guidelines.
For a moment,
You are challenging a transfer order.
Lordship. Now, this transfer timeline provides that transfer exercise may be completed within June every year based on the tenure completed by the officers' employees as on 31st March of respective year. However, on exigency like resignation, superannuation, or demise, officer employees may be transferred during the entire year. So generally, it should be within the 31st March of every year, the transfer exercise has to be done. They have to find out whether transfer is required, and if it is required, they have to complete it within, so that, because in between, if a officer is transferred, some problems arise, like students going children, they have to also been taken. So that was a good policy, Your Lordship. Now they have issued this impugned order on 6/8/2025. That is after 31st March. 6/8/2025, the impugned transfer order was issued. Now, this transfer timeline also provides that if there is
Where, which page?
Lordship, which one?
The impugned transfer order,
Lordship, will
page
that-
34.
Page 24.
Huh?
Impugned, page 21, Your Lordship,
Transfer order is at page 21.
page 21. That order was issued to me.
Yes. Affidavit's been filed, na, Mr. Ganguly?
Now, Your Lordship, this transfer policy itself provides a grievance redressal mechanism. As per this transfer policy, which Lordship will find at page 22, Your Lordship, page 24 again.
But these are all procedural. I'm indicating you.
I also know
These are procedure
limitations, Your Lordship,
Hmm.
transfer matters.
So you come to the main point. If you have anything to show that you've been arbitrarily or in a discriminatory manner being treated.
Lordship. Now, grievance redressal on transfer is there. There is a mechanism provided, which provides that if any employee having any grievance due to transfer, he or she can appeal to grievance redressal committee within 7 days of transfer, and the committee must dispose of the appeal within 15 days. Grievance received from the employees citing violation of transfer policies be dealt with in considerate manner and suitably responded to by duly recording the reasons thereof. And there is a 3 members committee, it has been specified. Now I filed an appeal, Lordship. That appeal was considered and disposed of in a single line without giving any reason as to why my grievances have not been considered. And the authority who has issued that order, he is also not the competent authority as per this transfer policy guideline, Your Lordship. Now, Your Lordship, they have filed an affidavit in opposition, which Lordship will find at page number 37, it starts. And their contention is based on a letter dated 15/7/2025, page 45. According to them, there is a letter from general manager, from regional manager to the general manager, indicating that, may I read, Your Lordship?
Yes.
In reference to the subject cited above, we are facing acute shortage of manpower in our region. And in few cases, there is also no minimum staff for looking after day-to-day affairs of the branches. In recent time, the number of staffs, including clerical cadre and officer, have been drastically reduced due to retirement, resignation, and death. 6 employees have resigned, 1 officer retired with effect from so-and-so. Moreover, 5 officers and 6 employees to be retired within this financial year. It may be noted that 11 number of branches.
Mr. Loscott, just 1 second. Yes.
So this letter shows there are shortages in different branches, Your Lordship, and there is a requirement of transfer of some officers, Your Lordship. But it is not a case that suddenly one officer died and therefore their exigency came. It is a general letter written thereby. And pursuant to that, Your Lordship, they have issued this impugned order as page 46, Your Lordship. On the basis of that, the transfer order was issued. Now, this letter is again under a misconception of facts, which I'll point out to your lordship. This is the transfer order issued by the competent authority, and based on that, the transfer order was again issued to me. May I read your lordship?
Yes.
For operational efficiency of Kokrajhar region due to large number of resignations in the region, it has been proposed to transfer officers completing 3 years in other region. Lordship will kindly mark that those officers who have completed 3 years in other region, they are supposed to be transferred under this policy. Region office. Now, considering the above, the following officer having experience in the back and also completed more than 3 years in DP
Mr.
region.
Ganguly, try and find the case of Rima Tasso,
Yes, come with
this
this.
court.
Look, I have.
Just get hold of that if you can. In fact, coincidentally, it was my first case argued. I was in the shoes of Mr. Lohkar and I lost. I was almost arguing the same points. Yes, yes, it was. It was. Try and find out. Get hold of it. 2000 probably 4.
First case.
Lordship may have it
Yes.
perhaps later today or some other.
Just see, I think it will come.
I will.
Or should I keep this at 2 o'clock?
Lordship may have it at 2.
Huh?
I'll find out.
Because I've invested some judicial time with the for only to endeavor to dispose it of.
Otherwise, the law is settled.
Correct,
I-
but
no,
because whatever Mr. Locker is arguing
those are answered in the
is answered in that case.
lodge. I'll find it on place.
Rima Tasso, it's reported.
Lodge will have it at 2 o'clock then.
I'll also go through your lordship.
You have a look at it.
Obliged.
Yes, Mr. Yassin.
Lordship, this writ petition pertains to dismissal from the service, Your Lordship.
On what ground?
The ground is that, Lordship, I have took some illegal gratification from some social organization, anti-social organization, Lordship. So my appeal was not considered on the ground that, Your Lordship, I didn't got the opportunity for cross-examining the witnesses.
That's exactly when I said on one ground, what I meant is
Yes.
on what ground are you assailing your dismissal?
Lordship. Lordship, I have
Violation of natural justice.
violation of natural justice, Your Lordship.
And
Lordship, what had happened in this case, Lordship, we have conducted a search operation along with my seniors officers of the department. So we have nabbed drug peddlers from a certain point at Nagar, Lordship. So I was the reliable intel of the department, Lordship. I was rendering my service with utmost sincerity and loyalty to my department, Lordship.
but now you are before a 226 court.
Yes, Lordship.
And the 226 court have a very limited
I totally understand, Lordship.
you see jurisdiction
But Your Lordship will see the departmental proceeding.
go through whether that dismissal is valid, not valid. There
Yes,
are
Lordship.
this court is not going to go into the factual
Absolutely. Lordship
aspect,
is correct.
nor sit as an appellate authority over the
Absolutely.
order of dismissal.
Right.
So that is why if there are any violation of procedures, natural justice,
Lordship.
any law
Lordship.
not followed, then you point out
Absolutely.
affidavits have been filed.
No, Lordship.
Oh, affidavits not come.
Lordship,
Keeping quiet. Admission matters generally.
He knows on the morning lordship, I already.
But you must tell me, why are you not saying? Anyway, then how much time?
Lordship.
Huh?
4 weeks time, lordship.
4 weeks
Yeah,
time.
yesterday I wrote letter, lordship.
Mr. Yassin,
date will be fixed.
Mr. Yassin, first of all, you have taken steps only 2 days
Lordship,
back.
that is.
So now you
not
leave
my
it to
fault
the
because
court.
I was not available in Guwahati, Lordship.
That is your
I
problem, Mr. Yassin.
I apologize.
Heard Mr. Y. Yassin, na?
R. Yasin, Lordship.
R.
Yasin.
R. Yassin, Learned Counsel appearing for the petitioner. Also heard Ms. M. Bhattacharjee, Learned Additional Senior Government Advocate for the respondents. Ms. M. Bhattacharjee, Learned so and so submits that steps are pursuant to issuance of notice on 25/9/2025 has only been taken yesterday. When?
27.
On 27/10 on 27/10, no?
Yes,
On 27/10/2025. She further seeks a short accommodation to file return in the matter. Released after 3 weeks or 2 weeks?
4 weeks, lordship.
3 weeks. 3 weeks on a date to be fixed by the registry to enable the state respondent file return in the matter. Yes, next.
Biplab.
Item number 32 and 33. Lordship, in this matter, Lordship, praying
Yes,
for-
Mr. Das?
Yes, praying for some time to file our affidavit of opposition. The petition
All right.
is very bulky. Short date, please, two seconds.
Short date,
Lordship, we have received the.
25 matter. Yes, sir.
On the matter.
As prayed for by Mr.
DJ Das.
DJ Das, Learned Counsel appearing for the respondent numbers 1 and 2.
Yes, Lordship.
1 and 2 relist after 2 weeks on a date to be fixed by the registry to enable the respondent file return in the matter.
Okay.
All orders, item number 17.
Yes, why is this in the order?
Lordship, in this case, for response number 6 and 7, notice served. Notice could not serve, Lordship.
Why?
Lordship, there is a report, office note dated 17/6/2025. It says addressee could not found.
So
I would
what
like
is
take
to be
step,
done?
Through paper publication, Lordship.
Huh?
Through paper publication, I will like to take steps, Lordship.
Let him.
This meter is regarding the quantum of the error. So whether the driver and the owner of the vehicle, I am for the claimants.
And he's for the insurance.
He is for the insurance.
If tomorrow we find that the insurance is not liable, then who will give you?
Honor is the necessary party.
Huh?
Honor is the necessary party.
Let him take fresh steps.
Only,
That's all right, but let he's made a party now. It's an MAC appeal. We cannot ignore it. Mr. Arna R. Sharma, Learned Counsel appearing for the appellant, seeks service in respect of respondent number 6 and 7 by paper publication mode as steps could not be taken in respect of respondent number 6 and 7 as per the earlier order passed by this court through the registered post AD mode in view of the fact that due to their in view of the fact that unserved notice has been received back with postal remark not known. Steps could not be completed, taken by. Let steps be taken through paper publication mode in 2 newspapers on when?
Date of appearance maybe on.
That I will give. So within
1 week.
within a week from today, fixing the matter on when?
15th December. 15th of December.
15 December, so and so.
Apply, Lordship.
With intimation of the next listing of the date in the published note in the publication.
Apply, Lordship.
Item 18.
Contempt matter.
Lordship.
Yes.
We have filed the affidavit today. It's being filed.
Decca, you have filed.
Yes, Lordship. Today we have given a copy to them all.
Yes, Lordship. And since it is against they are denying.
You want to file something? Heard MS Najneen, na? Sorry.
S Kanun go,
S
Lordship.
Kanun, correct. MS S Kanun, Learned Counsel.
S Kanun go, Lordship.
Kango, Learned Counsel appearing for the petitioner. Also heard Mr. D. Decca.
Yes, Lordship.
Learned Counsel appearing for the contemner stroke respondent number 4. Mr. So-and-so submits that an affidavit in opposition has been, the reply pursuant to the show cause received has been submitted today by the contemner number 4. However, the same is not available on record. Let registry verify and place the same on record. Relist on after 2 weeks.
2 weeks.
On a date to be fixed by the registry. In the meantime, the petitioner is at liberty, if so advised, to file rejoinder if necessary.
19.
My lord, I am in this matter, I am appearing for FMT60, my lord, respondent number 1, my lord. Here, my lord, verification process is going on. Moreover, report from the school and inspector of school has also come, my lord. So sometime it's required, my lord.
All right, let them file. It come today after notice first time, I think, no?
No, Lord,
Second time.
second time. That I have taken.
No problem, let them file.
But if the other similar matter, Lordship, is fixed on.
All right, we will do it. Heard Mr. No need. Heard Mr. Nath. DC Nath, Learned Counsel for the petitioner. Also heard Mr. U Sharma, Learned Counsel, appearing on behalf of the respondent stroke contender number 1. Mr. So-and-so submits that that the verification process in order to release the claim of the petitioner as per the judgment and order of this court against non-compliance of against which is the subject matter in the present contempt case is going on. List on such and such date. Give that date.
18/11/2000.
So and so along with
contempt number 259.
4 weeks is required to.
so and so, huh? And then you say it appears that it further appears from the office note dated 15/9/2025 that service in respect of R2 is awaiting. Let up-to-date status as regards service of so and so be placed by the next date of listing.
And item number 21, Lordship, was the same.
Same. Okay.
21.
You are only appearing in 21?
Yes.
Okay.
Item 20.
Yes, Mr. Kaushik.
Allow 2 weeks time to complete my instruction.
All right. Heard Mr. A. Gohai, Learned Counsel for the petitioner. Also heard Mr. B. Kaushik, Learned Counsel, appearing for the contender number
1 minute.
1, and Mr. C. Barwa, Learned Counsel, appearing for the respondent stroke contender number 3, and Mr. B. Deori, Learned Counsel, appearing for contender number 5. Correct? Anyone for 3? You are for 3.
Yeah.
What about 2, Chalia?
2,
And Chalia for 2. He was here. Just inform, huh? Who's going to put the I think all of you have to file at the end of the day.
Yes,
As prayed for on behalf of the contemners, relist after 2 weeks on a date to be fixed by the registry to enable the respondent contemners put their response in terms of the show cause issued by this court on notice date, Mr. Gohai. When was notice issued? It's 15/7/2024. Mr. Chalia, I put your name in this case. File your return. Yes.
Item 22.
May it please your lordship?
Yes.
Your lordship, may peruse office note dated 7/8.
7/8 indicate service has been complete. None appears. Today also same position.
Lordship, service is completed, your lordship. But nobody has
Contempt? No, this is for what?
Continuation of delay of 9 days.
9 days.
9 days.
Likha. Your name?
P. Bodhakur.
Heard MSP.
Bodhakur.
Bodhakur, Learned Counsel, appearing for the petitioner. Applicant. Stop. Despite service being completed in terms of office note dated 7/8/2025, there is no appearance on behalf of the respondents on call. Pertinent that on the last occasion, i 11/8/2025 as well, despite surveys being completed, there was no representation on behalf of the respondents for which the matter was posted today. Be that as it may, the interlocutory application is being taken for final disposal. By way of this application under Section 5 of the Limitation Act 1963, read with proviso to Section 173 of the MV Act 1988, as amended for condonation of delay of 9 days in filing the connected MAC appeal. Stop. The grounds of delay is stated as under quote unquote paragraph 2, paragraph 3, and paragraph 4. Perusal of the aforesaid grounds It appears that the said delay of 9 days occurred due to some delay on the part of the Learned Council owing to health issues of his family, comma. The same appears to be sufficient and bona fide. Hence, in the interest of justice, the delay of so and so stands condoned. The MAC appeal is registered.
No, you're not.
Register. Huh? Disposed of.
On that.
Item number 23.
Yes, contempt, respondents
Well, I have reached my instruction. We have already complied with the order.
complied.
Yes.
Mr. Gohai,
I have not.
have a look at it. You have a look at it while I'm taking up the other matters. You have a look and you let us know if you are okay with it. After some time. Just inform, huh?
Yes.
Don't go, you wait.
No.
Yes.
24.
May it please your lordship.
Yes.
So as per office note dated 13/10/25, notice upon respondent number 1 served. 2 and 3, my lord, AD not returned.
2 and 3?
Not
You are for 1, Mr. Biswas? 2 and 3 is still awaiting.
still awaiting.
All right, Mr. Biswas.
Yes.
Await service in, please put their appearances. Huh? Await service in respect of respondent number
2 and
2 and 3. Relist after 2 weeks or 3 weeks?
No, my friend.
2 weeks on a date to be fixed by the registry.
My lord, my lord, I have for stay of the judgment that is pending for disposal, my lord.
On that day, let the service be completed.
My lord.
I also, next. Yes.
High lord, please.
Item 25.
Yes, Mr. Agarwal.
Yes, now please be my lord.
IA is for what?
Still 50% the award is, they were to have been deposited but not deposited, lordship yet.
Why, Ms. Majumdar?
Not
And-
deposited.
Not deposited.
Amount deposit for amount.
And
I didn't know that.
as and when it is deposited, that may kindly be released also.
I've informed them about it. I'll
No,
take instruction. now.
You'd have your instruction, but
Yes.
this IA is for what?
For deposit and the release again, they are.
As
also-
per the earlier direction.
Yes, yes.
There was already a direction.
This-
No, not to release.
Not to
lordship.
release.
In this application, lordship, this application won't be maintainable because he has not made the owner and driver party in the I.
You do one thing, you first have
Yeah,
your
yes,
instruction.
instruction,
As
that's
prayed for by MS so-and-so Majumdar, Learned Council appearing for the respondent, relist when?
After 2 weeks.
After 2 weeks on a date to be fixed by the registry.
I'll apply.
Item 26.
Correction.
My lord, we have filed on IA, there is request some correction
Huh?
of the cost title, my lord.
Correction of the cost title.
Yes, my lord, what happened? Wrongly, we have been mentioned that enhancement of the quantum of the award. Actually, it should be dismissal of the claim petition. Our claim petition was dismissed. In the matter of first line, my lord,
Okay.
and appeal under section 173.
By mistake, you had typed enhancement
Yes.
of the quantum.
Yes.
This mistake is because your office must be using copy paste.
Very true, my lord.
This happens in the chambers of busy lawyers. All right, I'm allowing it. Heard Mr. S.E. Biswas, Learned Counsel appearing for the applicant. Stop. None appears for the respondents. I don't think any notice is required. By way of this application under Order 6, Rule 17, Red with 151 of the Code of Civil Procedure of 1908, as amended till date, comma, the applicant is seeking correction of the reason of appeal claim. Correction of the reason? Is praying for correction in the, you must ask your office to be a bit careful. Correction of the reason of appeal. Correction of correction in the cause title of the connected appeal insofar as that by insofar as inadvertently in the cause title, instead of dismissal of the claim petition, it has been typed as enhancement of the quantum of the award. Stop. Having perused the averments made in the interlocutory application, this court, before issuance of the notice to the respondents in the interest of justice, allows the application for making the aforesaid correction in the cause title. Stop. Let an amended cause title be submitted to the registry for doing the needful, disposed of.
And there's an appeal. Appeal is also there.
Appeal you first do. You first submit your amended cause title. Have you submitted? Yes.
Time being item number 23.
May I please, also matter is pertaining to release of minimum scale of pay on the basis of equal pay for equal work, my lord. There is a direction, my lord, in
Contempt.
case number 20, my lord.
Yes, my lord.
They have simply negated the claim, my lord.
Oh, the other one.
Yes, my
Yes,
lord.
my lord.
So now what to do?
So we have to silence it, my lord.
So it's complied. Give me that.
Yes.
Heard Mr. A. Gohai, Learned Counsel for the petitioner. Also heard Mr. Bidas, Learned Counsel appearing for the respondent stroke contender numbers 227, 226. Stop. By way of this contempt petition under Article 12 of the Contempt of Court Act 1971 and the relevant rules, the petitioner is drawing the attention of this court to the alleged willful and deliberate disobedience and non-compliance of this court's judgment and order dated 15/9/2023. Where is that order?
My lord, page 16, my lord.
Page
Page 16.
16.
Annexure A, page 14, my lord.
The relevant.
Relevant, my lord. 20, my lord, page 10, para 10 and 11.
Whereby the respondent APDCL was directed to consider the cases of the individual petitioners, and if they are found to have been working for more than 10 years up to the judgment of Uma Devi in Puratu Didibaha, I-10/4/2006, and were working against the sanctioned vacant post, and one time as in one-time measure, their services may be regularized. That's the order, isn't it?
No, my lord. And also, my lord, to release the minimum.
And thereafter, if they are found not to and in the event they are found not to have worked for more than 10 years up to 10/4/2006, but have worked for more than 10 years in the meantime, to consider benefit of providing them the salary at least in the minimum pay scale that are otherwise payable to an equivalent regularly appointed employee. Full stop. Paragraph
11 is my lord also.
Paragraph 9, 10 and 11 is extracted hereunder for ready reference. It appears that apart from the above direction, the respondents were also requested to consider the case of the petitioner and find out a suitable economic package for those petitioners who have worked who may not have satisfied the requirement of having worked continuously for 10 years. As per the acceptability of the respondent APDCL. Stop. Today, when the matter is called, so and so places an instruction dated 4/5/2025, whereby which reads as hereunder. Speaking order places the speaking order dated 4/5 so and so issued by so and so. They said speaking order dated so and so reads as hereunder, quote unquote. Reading of the so and so, it appears that so they don't complete 10 years.
On also the documents showing that they are working continuously with the APDC.
Hello, they are.
No,
More than
consider,
40 years.
no, it appears that the petition that the respondent has already considered the case of the petitioner, has complied with the direction of this court. However, that being so, nothing survives for adjudication in the matter. However, if the petitioner is not satisfied with the outcome, the petitioner is at liberty to approach the appropriate forum in this regard. Disposed of. Closed, huh? The speaking order so and so is kept on record.
Item 27.
And you record that Mr. Gohai says that they have complied also. Mr. Gohai, I've recorded voter submission that he says he has complied, which you don't object fairly. That I have just recorded, and I have given that liberty. You do whatever you want to do, because that is not the jurisdiction of the contempt court. Yes.
May I please. My lord, this matter pertains to the release of salary of the petitioner. My lord. So as per the official note that, my lord, the service is complete, my lord, in respect of all the respondents.
Not complete.
Not complete. Complete means, my lord, so far as the tracking report is concerned, my lord, it shows that the notice were delivered to the respondents. For 1 and 2, lord. The last paragraph, my lord.
Postal tracking report shows that items delivered, so it's complete.
Yes.
Heard Mr.
A. Ali.
A. Ali, Learned Counsel for the petitioner. Also heard Mr. S. Das, Learned Counsel. S. Bhuya, Learned Counsel, appearing for the respondent numbers 1 and 2. Office note dated 29/10/2025 indicates that indicates that service in respect of the other remaining respondents stands complete. Relist after 3 weeks. You file your affidavit, 3 weeks on a date to be fixed by the registry. In the meantime, respondents shall file their affidavits, shall submit their returns if so advised.
I'm obliged.
28 and 29.
May I please join us? That's it. In this matter, I am appearing for respondent number 6 to 20.
Are you objecting to the impleadment?
Yes, Lordship. I have filed yesterday, but it's not in record. Lordship.
Why are you objecting to the impleadment? Who you want to implead, Mr. Kaushik?
These applicants are the participants of the recruitment process, my lord. Subsequently, when
More the merrier.
and when the written test was over and a list was notified, the persons who have qualified the written test, we are among them, madam. In the written, we have qualified.
No, Lordship.
And they have challenged the entire recruitment process.
Because Lordship, in IA does not include any documents that the applicant are selected.
They will put it in the writ petition. This is not they are not filing a defense here. They are prima facie on the sworn affidavit. It appears that they have some grievance. Otherwise, why should they join in? Why would anybody like to be joined in a petition?
Selection committee.
I understood, but you see, the concept is necessary and proper parties, right? They may not be a necessary party, but they may have some interest.
In
So let
fact,
us
any order that
have
we
them.
passed would
It might
adversely-
have.
It adversely
Where is that objection? You have a photocopy?
Yes, Lord.
Give it. You call for it. I'm disposing it off. I'm allowing it the impediment. Anilok. It's filed, na?
Yes.
You have received. Okay, I'm disposing it off. Huh? I'll take your affidavit on record too. At Anilok. Heard Mr. B. Kaushik, Learned Counsel, appearing for the petitioner. Also heard MS RR, na? RR Kakuti, Learned Counsel, appearing for the respondent number 6 / writ petitioner. And yes,
No, so we have from the government, so we have no.
Mr.
CKS.
CKS Barwan, Learned State Council. Stop. by way of this application, comma, the applicant is seeking impleading of the applicants. Okay, how many applicants?
Respond number 6 to 15.
No, where do I get the names?
Names, my lord, will
This
find-
1 to 5, no.
Page number 5.
This name of what?
26
Impleading of impleading of the applicant of the applicants, i.e. 1, 2, 3, 4. Oh, then you have to give all their names, huh? 1 to 26. Didi Basabarena. 1 to 26. In the connected writ petition, IWPC number 1256/2024. The present impleading application has been filed by the above by the aforesaid by the said 26 numbers of applicants as they have also participated in the written examination of the advertisement involved in the said writ petition, and they have successfully passed the written examination and were called for interview for Viva Foci, which was held on 29/2/2024. The relevant paragraphs of the impleading application reads as under 2, 3, 4, 5, 6, 7, 8 also.
Yes, no. 8 also.
8. Reading of the aforesaid paragraphs, it appears that the applicants have participated in the selection process and appears to have been declared as success no, have you been declared as successful?
No, passed the written examination. The Viva will say result
And is stated to have passed the written examination for which they were ultimately called
for the Viva.
for the Viva Voce test, which you appeared.
He appeared, but because of the interim order, results are not declared.
It is the further, it further appears that though they had appeared in the said Viva Voce test, however, the results have not yet been declared in view of the interim order
Yes, brother.
passed in the connected writ petition. That being in view situated thus, the present impleading application has been filed. Mr. B. Kaushik, learned so-and-so submits that the presence of the applicants are necessary and proper for effective adjudication of the writ, in as much as in the event any orders in the event in as much as there is a possibility that if the in as much as if the relief sought for in the writ petition is allowed, the petitioner, the applicants may be affected. Stop. Per contra, MS so-and-so submits that an affidavit in opposition has been filed today, filed on such and such date, whereby the petitioner has objected to the impleading application. Relevant paragraph of the affidavit in opposition, which paragraphs? What's the main ground of opposing?
Because they does not include any annexure that we
She further submits that no details whatsoever is enclosed in the impleading application to indicate that the petitioners have participated or have been or have appeared in the Viva Voce test as claimed in the interlocutory application. Having heard the learned counsels and having perused the pleadings, including the affidavit in opposition filed yesterday on behalf of the writ petitioner, this court cannot ignore. This court is of the opinion that since the applicants are claiming by way of the instant application that they have participated in the selection process and have also appeared for the viva voce test, their presence may be necessary, may be proper for the effective adjudication of the writ petition in hand. Stop. That apart, in the event the claim of the applicants appears to be correct, in that event, any orders passed in the writ petition may affect the rights of such parties. That being so, this court, in the interest of so and so, deems appropriate to allow the impleading application. So and so are all allowed as a respondent numbers 6 to 23 in so and so. Let amended cost title be submitted before the court, before the registry of this court. In the writ petition, not likhideba, interim if any to continue. And when do you want the writ to be listed?
Let a copy of the repetition be served upon.
Then I'll issue notice.
Yes, sir.
In the writ, in view of so and so, we let notice be issued to the newly impleaded so and so. Mr. So and so accepts notice and list after 3 weeks on a date to be fixed by the registry, and interim, if any, shall continue till the next date of listing. And that amended cost title, you give it within 2 days, 3 days. Who will give?
I'll give.
You are not the writ petitioner.
I'll share the amended copy.
You share it with. No. After 3 weeks, I have posting it, but that cost title you have.
4 days.
You do it in 4 days, because the registry will have to make the changes. Otherwise,
Yes.
to 4 days, that amended cost title by the petitioner. And extra copies, didiba notice that to be cautious. Yes.
Grateful, madam.
Yes. What about item 29?
Yes, sir. Connected matter.
So 20, you are only seeking impleadment in 28. 29 to get 3 weeks diba. List along with query. So interim if any.
Grateful.
Item 30.
Yes. What?
In this case, I find this IA, my lord. Initially,
First time it has come.
yes, my lord.
All right. Have it.
Yes.
Aspirate for by Miss. Will you give him a copy?
Yes, yes.
I'm issuing notice. Heard Mr. H. Das, Learned Counsel, appearing for the petitioner. Also heard Mr. J.K. Goswami. J.K. na?
J Hendik.
Oh, J. Hendik. For a moment, I thought J.K. Goswami. J. Hendik, Learned Government Council.
Lordship, I appear on respondent number 1.
Learned Counsel appearing for respondent number 1, and Mr. D. Barwa, Learned Counsel, appearing for
Respondent number 234.
234. State Council? State Council. Issue notice, so and so accepts, and 3 weeks. Extra copies, Yes.
Yes. I seek some time to find that.
And in the WPC, as prayed for, relist after 3 weeks to enable the state respondent file return in the mat.
Double S.
Standing item number 14.
Yes.
This is a matter regarding compassionate appointment, my lord. Yes, circular has come, my lord. I am praying, my lord, direction from your lordship, my lord, to consider his case along with other matters, my lord. Otherwise, my lord, he has already obtained.
There is one executive order that has come, lordship, that is on. The date is lordship 38 August 2015 to 2025, and there is a table, lordship, type of cases, how the cases to be dealt. Here in this case, lordship, the date occurring 2008, and in the
Where are all those things?
in the table, lordship, I have already mailed him.
No. Mail means?
emailed the executive order of 30th August 2025.
I don't have it. Why are you not putting an affidavit? Where's the circular?
No, I know that, consider point. No, basic, I have already emailed.
Wait, you have a copy, you have a copy in the physical form. I'm having it on Monday.
Lots.
Released on Monday. Give him a copy.
This is unfair.
You give him also a copy.
absolutely.
Have a look at it, Barbhaiya.
Diplomat.
Yes. We're good.
Awesome.
On delivery of judgments, WBC 1568.
Sorry, Mr. Chaudhary, I may have kept you waiting for some time. A small error was there. I was correcting that. Hey. Come on, here you are suffering. Just reading the operating part of the judgment. In the present case, the respondent number 4 possess a section A and B associate membership course in civil engineering so and so awarded by ICI Ludhiana. And then accordingly, I have held issue number 1 against the writ petitioner. Issue number 1 is about this equivalence. Issue number 2, which is about the 2 post, not appointment to an unadvertised post, that is also held against the writ petitioner. As such, I'm of the unhesitant view that no case is made out. Accordingly, writ petition stands dismissed. Sorry.
Timing item number 15.
Could you locate that?
Yes, my lord, I've got it.
Have you, Mr. Laskar, have you seen?
Yes, I have got it.
I think
is almost
similar arguments were made there.
almost. Remark Tasso versus State of Arunachal Pradesh. Decided on 12/8/2004. Paragraph 5, Lordship, the court has.
Yes.
Paragraph 5 of the judgment.
Yes.
The rival submissions advanced on behalf of the contesting parties have received due consideration of the court. The power to transfer of a government servant from one location to another has all along been recognized by the courts to be exclusive power of the state. It is the employer state who would be the best judge as to how the service of a government servant should be utilized in the interest of administration. The broad and wide powers vested in the state have definitely not been free from abuse, and that is why approaches are made to the court from time to time. The state in its wisdom has also thought it appropriate to frame policies regulating the transfer of government servants in order to avoid any heartburning and misuse of powers. However, the terms of such a transfer policy as framed by the state have been held by numerous judicial pronouncements to be in the nature of guidelines which should normally guide the action of the state. The terms of the transfer policy framed by the state itself are normally to be followed and cannot be departed from arbitrarily. But keeping in mind the paramount power of the state to transfer its employees, and also having regard to the fact that there is no vested right in any employee not to be transferred, departures from the laid down norms can be made by the state, provided such departures are justified by placing before the court the reasons for such departures. The terms of such a policy have therefore been held not to be conferring any vested right in an incumbent to have the said terms enforced in his favor by the court. The power of the court to cause interference with the transfer order must be viewed from the aforesaid context, and if the said power is so viewed, the result that emanates is that the power of interference under Article 226 of the Constitution must be held to be an extremely limited and circumscribed power which has been evolved by the court primarily to check arbitrariness and misuse. A transfer made within the four corners of the policy can naturally invite no objection. A transfer made in departure to the laid down norms, if the reasons for such departure are satisfactory, must be construed in favor of the state in view of the fact that the state must be acknowledged to be the best judge of how the administration is to be run.
Yes.
Your Lordship, in this case, Your Lordship, correct. It is generally they who have to decide where to go, how to go. And in this case, it is an administrative position, there is violation of the guidelines. Now I'll take your lordship, the transfer order that they have annexed in their affidavit at page number 46.
Yes.
For operational efficiency of the Kokrajhar region due to large number of resignations in the region, it has been proposed to transfer officers completing 3 years in other regions. So they have taken a conscious decision that those officers who have completed 3 years in other regions, they may be transferred. But my case, I think it has been considered a misconception of fact. I have not completed this 3 years tenure.
Have you filed a representation?
I filed.
What happened?
They disposed it of, but without assigning any reason. That is also there in the. They disposed it of, but without assigning any reason. But transfer policy says that.
What do you have to say to this, Ganguly?
No, the reasons were as such in
No,
detail.
because that I'll go into, but page 46, it appears that your main consideration was to transfer those officers
Good.
who has completed more than 3 years in the Fu region, right?
Yes.
Now it appears that while doing so, you had transferred the petitioner,
Good.
but then he has not completed 3 years.
But the petitioner, my lord, I think joined in the
23/5/2022.
Yes. So, my lord, he has completed more than 3 years. He has completed 3 years now.
He says he has not.
No.
3/5/2022, I joined there. Lordship will find at page 13, 29/12/2022, I was placed under suspension.
That's all right.
Now suspension,
There
then
is a criminal case going on.
Sit down, sir.
Lordship.
Yes, all
Then
right, Mr.
I was under suspension for about 16 months. And then thereafter, an award of penalty has been imposed upon me. And in that order, it has been specifically stated that the period of suspension shall not be treated as on duty.
That's all right.
Now, coming to that,
That is for some other purpose.
in that view of the matter, I am saying that I have not completed the
Noted.
years.
Sorry.
Otherwise, your lordship,
Anything else?
it is in violation of the transfer policy.
Noted.
I rest my case here.
Sadly. What can, I mean, see, you can only do the best to the brief that you hold. The rest is, it has to follow as per the precedents and law. Now, this is one area where there is very less scope of interference, and those are settled. There is nothing, that kind of anything that has been brought to the attention of the court in this writ petition, which warrants, taking an exception. So these, in fact, if we start looking, there'll be so many cases which will say, no, the administrative instructions are not statutory, sometime violation. And in any case, your violation, you are only saying because of the 3 years, right?
One is 3 years, another is that they ought to have made the transfer within 31st of March. So
That is
they
the
have-
procedural.
procedure.
That is a
They
procedural
have made it
lapse.
in August, your lordship.
It's a procedural lapse. Tomorrow, গোটেইকেইটা হৈ গ'লতো
There is a
judgments.
interim order is there. Lordship. Interim order is operating.
I'm putting this tomorrow.
Only that one, whether this 16 months that he was out of service, whether that can be counted for the purpose of, because in the order.
That I have noted. Your
Yes.
I can dictate the just dictate to me. It will listen. Heard Mr.
MH Loskar.
MH na
MH Loskar.
H for Hyderabad.
Lordship.
MH Loskar, learned counsel appearing for the petitioner. Also heard Mr. A. Ganguly, learned counsel appearing for the respondent, Assam Grameen Vikas Bank. Stop. By way of this petition under Article 226 of the Constitution of India, the writ petitioner is assailing the impugned transfer order dated 6/8/2025 issued by the respondent number 1, whereby the petitioner was transferred from Difu to Kokrajhar in the post of
Officer.
Hmm?
Earlier I was manager, now they have given the post of officer.
Post of
Page 21, Lordship will find posted last
as
officer.
officer. The brief facts of the case is that the petitioner was appointed as Assistant Manager, Scale 1 of Assam Grameen Vikas Bank on 12/7/2013. Stop. Thereafter, he was promoted as Manager, Scale 2 on 31/3/2022 and was posted at Diangmukh branch of the bank, where after serving up to 26/12/22, he was attached, whereafter he was attached as Manager, Difu Regional Office on 27/12/22. And subsequently thereafter, he was placed under suspension on 29/12/22 on the ground of certain act of gross misconduct alleged to have been committed by him during his tenure at Diangmukh branch. This is pending.
No, paragraph 6, Your Lordship. Paragraph 6, it has culminated into an award.
Pertinent that upon a disciplinary proceeding having been held against the aforesaid allegation, in the inquiry, and the petitioner was found, the allegation leveled charged against the petitioner were proved, and thereafter the respondent authorities by order dated 25/4/2024 imposed major penalty of reduction of basic pay by 2 stage in the time scale of pay for a period of 3 years with cumulative effect. Stop. Thereafter, the petitioner was reinstated into service on 21/5/2024, and he accordingly joined as Manager of Difu Regional Office, and since then he has been discharging his duty in the said office. Thereafter, on 6/8/2025, the respondent number 1 issued the impugned transfer order, whereby he was transferred from the post of Manager Regional Office Difu to the post of Officer at Serfanguri branch under Kokrajhar region. It is the specific case of the petitioner that the impugned transfer order was issued in violation of the provisions of the transfer policy of Assam Grameen Vikas Bank 2025. Stop. Situated thus, the present writ petition has been filed. Mr. So-and-so submits that the transfer policy provides for transfer timeline, which provides that transfer exercise may be completed within June every year based on the tenure completed by the officer/employees as on 31st March of the respective year. And only on exigency, an exception like resignation, superannuation or demise, an exception was made whereunder officer/employees may be transferred during the entire year. Correct? Stop. He further submits that the transfer exercise accordingly is required to be completed within the month of June 2025. However, the impugned transfer order having been issued on 6/8/2025, the same is in contravention of the timeline prescribed for transfer. Stop. He further submits that
Paragraph 12.
that though an appeal against the transfer order before the Grievance Redressal Committee was filed on 11/8/2025. However, the same was dismissed by the respondent number 3 on 26/8/2025 without considering the matter on merit. Stop.
Respondent number 3 is not the
He
authority.
further submits that the respondent number 3 is not the competent authority to issue the rejection order. Stop. Where is that 3 years?
Yes, Lordship, they have stated that they have taken a decision that those officers.
He further submits that under the transfer order, it appears that the reasons for transfer is
Contemplated for those officers.
for of operational efficiency of Kokrajhar region due to large number of resignations in the region, and therefore a decision was taken to transfer officers completing 3 years in other region to the said to Kokrajhar region. Correct?
Lordship.
However, the respondent ignored the fact that the petitioner has not completed the 3 years in the Fu region. Hence, the impugned transfer is totally arbitrary, discriminatory, and unfair. Stop. Per contra, Mr. Ganguly, so and so, submits that transfer being an exigency of service, comma, the same having been done for operational efficiency of Kokrajhar region due to large number resignations in the region, comma, the impugned transfer order warrants no interference from this court. He further submits that the timeline prescribed in the transfer where is that paragraph? In the transfer policy is not applicable to the facts of the instant case, in as much as it is apparent that it is due to resignations that the same has to be due to the large numbers of resignation in Kokrajhar region, the same had to be undertaken in the
To fulfill the acute shortage of.
correct. Had to be, but it was earlier. It was required to be done in June before 31st, na?
Yes.
Of
March.
Post 31st March of that year. Stop. He further submits that the petitioner having joined in the Fu region on 23/5/2022 has completed more than 3 years in the Fu region, and hence no ground of transfer can be, and hence the consideration of the respondent in transferring the petitioner cannot be assailed in the instant writ jurisdiction. Stop. That's
Specific allegation of malafide.
He further submits that there are no specific allegation of malafide pleaded in the writ petition. Having heard the learned counsels for the petitioners and having perused the averments made in the writ petition and considering the material on record, it appears that the petitioner was transferred from Difu by order dated 6/8/2025 to Kokrajhar, to Sarfanguri branch of Kokrajhar district on account of operational efficiency of Kokrajhar region due to large number resignation in the region. Stop. The above ground appears to be in the larger interest of the public, and hence doesn't call for any interference from this court. That apart, transfer being exigency of service, the petitioner cannot complain of being transferred out from DIFU, especially that he had joined DIFU way back that he had completed more than 3 years in DIFU region. As regards the contention of the learned counsel appearing for the petitioner, that because after he joined DIFU region, he was placed in suspension and he was not in duty for several years,
For about 16 months.
for about 16 months, the same cannot be counted in order to consider his period in DIFU, cannot be accepted for cannot be accepted for taking into account as per for taking into account in connection with transferring the petitioner out from DIFU to the said Kokrajhar region. Stop. Reference is made to the coordinate bench of this court in the case of Rimar Tasso versus State of AP so-and-so, reported in 2005, volume 1 GLR at page 1, wherein this court has held that terms of transfer policy framed by the state itself are normally actually because there is no departure. That ordinarily transfer policies framed by the state are normally to be followed. However, departure can be made in exigencies of service subject to the rider, of course, that the same cannot be departed from, cannot be done in an arbitrary manner.
Should I hand over the judgment of the revision bench specifically?
Is there something there?
Yes, as to why, even if there is a violation, they should.
That's all right. You see, I have hold there is no violation. Where is the violation, Mr. Ganguly? No, you see,
Yes.
that period,
Lordship.
there was an however subject, right?
Lordship.
Resignations. There was those exigencies.
Yes, and it is on account of that exigency.
Correct, your ground, that is it is very clear.
Are actually taken out for.
And he's right that he may not have physically been in DIFU
Yeah,
for more than 3 years.
yes.
But then that is because of his suspension. Now that period is not counted, that benefit and all.
Is non-malod.
Correct, that is different.
Yes.
That is for the other benefits. But as far as that is concerned, he has spent
Yes,
in DIFU.
he has spent. On record, he has spent in that.
Correct. I may edit it little because I just broadly gave it. So you may not get this order today itself because otherwise I'll forget.
Obliged, Lordship.
Sorry, Mr. Locker.
I'm obliged.
We're going,